Good morning, Instagram. Happy 2025. Good morning, Facebook. Good morning, YouTube. How's everyone doing? Hope you guys had a wonderful holiday season. We are in 2025. Good morning. If you're new here, comment, let me know where you're tuning in from. So I can give you a shout out. Francis Ninja, welcome. Good morning. Jigger Up, Grand Rising, Arewa, Happy New Year to you as well. Good morning, Nestle Lady. Patrick, good morning. YouTube, if you are here, comments. Facebook, if you're here as well, comment. I was meant to go live today as well on TikTok, but I left my other phone somewhere. I don't know. Tassina Marine, good morning. Someone says they have a question. Jump right into it. You can ask your question right away. So for those of you who don't know me, my name is Aisha Chidole. I'm an immigration lawyer and I help clients all over the United States with their family immigration matter, complex immigration issues, humanitarian-based cases. To schedule a consultation, you can call 407-995-6567. You can also send a WhatsApp to 404-333-8751. Okay, let's dig right on in. Gillibat says, I love your smile. Thank you so much. Someone says, as an international student, is it easy for me to get a working visa? No, it's not. You don't have a right to a working visa as an international student unless you get OPT, right? You can get OPT where you have occupational training, which will allow you to work for a year after your program. If you're in a STEM major, then you can get OPT of 3 years. But after that, you're going to need to either find someone to sponsor you, or there has to be something else that makes you eligible to continue to work. For some people, it's through an employer who files an H-1B for them. For some people, it might be a family member that that's able to petition for them. For some people, it's marriage. So usually there's something else that should transition you if it's not for a job offer. Tamar James, good morning. West Side from Maui, Hawaii. Wow, how exotic. Good morning. I'm sure you guys have an amazing weather right now. It is super cold here in Atlanta. It's supposed to be snowing this week, so we're going to see if it really happens. Someone said, I have a family member in need of your help. Tell them to call us. We'll be happy to speak with them. The other person asking, how do I schedule a consultation? You schedule a consultation by calling our office, the 407-995-6567, and then we'll get you scheduled for a consultation. My I-751 was adjusted to 48 after filing the waiver. That's normal. Once you have an expired or an expiring I-751, an expiring 2-year green card, I should correct myself. If you have a 2-year green card that's expiring, the minute you file for your I-751, what happens is you then get a 48-month extension on your temporary green card. So that 48-month is not an approval. A lot of people think that, when they get a receipt and it says we've extended your green card for 48 months, it's an approval. It's not an approval. It's just extending your temporary green card so that they can make a decision or not if you should get permanent residence or permanent green card. Makantra Ore says, Happy New Year. USCIS requested my birth certificate for my I-485. Is that a good sign? It doesn't mean anything good or bad. They don't have a copy of your birth certificate and they need your birth certificate to make a decision. Without knowing your case, where you are and what stage you're in your case, it's really hard for me to say. But they need a birth certificate as part of a decision-making process. If you don't have one, or you have one that's like a short form instead of a long form that includes both your parents' names, they would usually request one. So that's what it is. Trudy, blessed New Year to you as well from Facebook. And Bella Love, good morning. Happy New Year to you as well. All right, let's see. AA says, you're looking gorgeous. Thank you so much. Gilly Bat, you guys are so free with compliments today. Thank you so much. How long does an I-751 take to process if divorced, basically to be approved? Takes about 2 to 3 years. So similar timeline with a vow self-petition. The timeline is just the same. If my I-130 is still pending, can I still file for VAWA. You can file for VAWA if you are eligible to file for VAWA. So you know, as long as you're eligible to file for VAWA, even if you have an I-130 pending, you can still file for VAWA. Also, if you have an I-485 pending, but that spouse who is sponsoring you all of a sudden becomes abusive or has always been abusive, and you know, you just never had the courage or didn't know you had an option, you can still file for an abuse-based VAWA application. You know, while that case is pending. You know, there's a process to basically hold on to the originally filed I-485 to help you preserve like your work permit and travel permit while, you know, you switch over your case. How long after the VAWA approval do you get a green card? It really depends on what you've submitted with your I-485. Sometimes if you've not submitted your medical, they may ask for your medical. If you have, usually I'll say give or take for most people, it's going to be 6 months, unless there's something else that they're looking into. But on average, most people, it will fall somewhere within that 6 months. And again, for those of you guys, you know, I might have mentioned this last year, just as another reminder, you know, going into the new year, with the new year, you know, you must send your medical exam at the time of submission of any I-485 application. If you do not send it now, your case can either be rejected or denied. So you must make sure that you're sending it. USCIS is, you know, on a fast track changing forms right now, you know, and one thing I'll tell you guys is that it's not the end of it, because, you know, for instance, you know, USCIS has said we're introducing a new form that's going to, well, they changed the form a couple of weeks ago, right, to the version that we're currently using now. They're going to change the forms again, you know, on February 10th. But I guarantee you that between January 20th and even February 10th, there's a possibility that they may change the forms again, because, you know, once President Trump gets sworn in, he is probably going to institute or implement the well test again, which is basically the I-944, where it's called, it's like the public charge rule. And the public charge rule basically makes it more difficult for those who are married to U.S. citizens or family members of U.S. citizens to get a green card if they cannot show that they meet certain financial and educational, you know, background. So, you know, you want to be mindful of this, you know, especially for those of you who, you know, might fall into this category, you know, because they will be looking at your finances. They will be looking at your spouse's finances. They will be looking at your credit scores. They will be looking at your educational background. They will be looking at your ability to speak English. They will be looking at health insurance coverage. These are all things that were instituted for marriage-based cases in 2020, not 2024, in President Trump's previous administration. And these will probably be coming back in this administration. So you really want to make sure that you're being very diligent, you know, about protecting your credit, watching your finances, just making yourself look very desirable to the U.S., so that when they are making decisions, they can say, okay, this person is not going to be a burden, you know, to society, a potential criminal to the U.S. Someone says naturalization will change. I don't know. The only things I'm speaking of right now are things that were implemented in Trump's previous administration, which most likely will come back because he felt strongly about that. I cannot predict, and I will not predict what else will change, because we don't know until he does it. So I don't believe in creating a false narrative or stoking fear. When the rule happens and it becomes a rule, I will tell you. I'm only telling you as a matter of fact what was done before, and that we expect those things to continue to be done. And, you know, yeah, so that's it. Someone said, what about my daughter filing for me as her mother? Same thing, you know, whether it's a marriage-based case or whether it's a mother filing for her daughter. Okay, the other thing, by the way, when you're petitioning for your parent, one of the things that, you know, they take into consideration, or they took into consideration in President Trump's era with the public charge, was the age of the parent that you were filing for and their health condition and the ability to pay for maintenance of that person. So if that person was, you know, has like a critical illness or like something that requires a lot of health, you know, insurance, they want to know that the person has the ability to pay for the health insurance, or that when it comes to the parentage. So every family-based petition, and when I say family-based, I'm talking about marriage, parent, or child, those will all be subject to the public charge rule. Those were subject to the public charge rule. And I suspect that's the only one thing that I can say that I feel pretty certain that he will probably bring this back, because this was something they felt very strongly about. Because even after he left, Biden kind of, when he dropped it, he then brought it back again, but just like on a lower level where it didn't require that level of evidence or documentation. So, which kind of means that they also kind of feel like this is something that we should know about whoever is applying. So I feel like that is something that I feel kind of confident that we will see. If we don't see it, I'll be surprised. Someone is asking, well, what about VAWA? Well, VAWA and humanitarian-based cases continue to be exempt. They continue to be exempt from public charge rules, because again, these are humanitarian-based cases. So they generally would not fall under the public charge rule. They did not fall under the public charge rule in Trump's administration, in Biden's administration, and I don't expect that to change in the new year. Okay. Adewale on YouTube says, if my prima facie determination expired, do I need to inform USCIS? No, you don't need to inform USCIS. USCIS knows that it has expired and typically will automatically send it to you. I will tell you that USCIS is notorious for sending renewed prima facie determinations late. So even if you've not gotten it, it's not a cause for concern. They will send it. They're just usually very late, like a couple months late in sending it. How long does it take to get a green card filed after getting a VAWA approval first? Medical and everything required. I just answered this question, so tune back, watch this back and listen to what I said. I filed a marriage-based conditional removal in March 2024. When do you think, from your experience, I'll be getting a green card? This is another question that I just answered. Timeline is 2 to 3 years for most removal of conditions. As a VAWA applicant, can a benefit like food stamps have effect? So let me be clear that I am not promoting anyone to be a public charge or to go take public benefits, but you are exempt from the public charge rule, meaning if you did take food stamps or, any of those things, these things are typically exempt. They don't affect you in your application, because by the very nature of a VAWA applicant, most times you're an abuser, most times you don't have the finances to support yourself. And USCIS introduced this Violence Against Women's Act law to protect victims of domestic violence and abuse. Again, even though the name says women in it, VAWA covers both women and men and children and parents who fall under this. So typically they are exempt from the public charge rule. Same applies to like T visa cases, that's trafficking visa cases, U visa cases where you're a victim of a serious crime, asylum. So basically humanitarian-based cases are typically exempt from public charge rule. Now, if you have a normal case where you're filing for your mom, filing for your dad, filing for your child, filing for your spouse, you will be subject to the public charge rule. You are currently subject to the public charge rule, even right now in the Trump Biden administration. The only thing is that the rule is a bit more lenient than what we had in the previous administration. So I am just preparing you guys so that you can prepare yourself, especially if you haven't submitted, to have what you need to make sure. So do not go running up your credit. You want to have money in your bank. You want to try to present yourself, as a desirable candidate for a green card here in the United States. Ian says, do you think VAWA applications will be delayed, or will it be faster because of the interview with the AOS? I don't know. Honestly, I don't know. So we're going to see what happens, because remember, majority of VAWA applicants are still not going to be interviewed. Remember, it is only just a select few. So majority of VAWA applicants are still not going to be interviewed. So let me be clear with that, because I've seen that question come a lot. Majority still, at least as of today, I don't know in the new administration. Trump's previous administration didn't do interviews of our applicants. So the new interviews right now are to make sure that people know what they're filing, because, a lot of people, I've definitely had consults come to me and tell me that they came from a lawyer or like someone that claimed to be a lawyer to file a VAWA application for them, but they were never married to a U.S. citizen, or they don't have a U.S. citizen child or a parent that's a U.S. citizen. And I'm like, or, green card holder. And so basically they were never eligible for VAWA, but somebody went ahead and filed it for them. So I guess the idea of this interviews, and just from listening to the questions that are being asked, is to make sure that people know what is being filed for them and that they're actually eligible for this, and they can actually articulate what exactly that they're seeking, right? Can a green card holder file for you to get a work permit? This is a good question. So the answer is that it depends. Let me tell you why I say it depends. If you have overstayed your time in the United States, meaning you entered into the United States correctly, legally, with inspection, but you have now overstayed your time, right? A green card holder can file an I-130 for you, but they cannot file a work permit for you because you are not eligible, or they're not eligible to file an I-485, which is a green card application. The same applies even if they have not overstayed. So there was a window over the last couple of years, I would say between 2020 to 2022, where if your green card holder filed for you when you entered into the United States and you were still in status, you could file the adjustment of status at the same exact time and the work permit and travel permit. But that was because the visas were current. So green card holders do not operate on unlimited green cards. They operate based on a limited amount of green cards based on priority dates. Once you become a citizen, then it changes. So based on that, you have to go based on each month what is current. So for instance, if let's say the easiest way for me to use this example would be, in the case of someone, let's say someone filed an I-130 for, like a green card holder filed an I-130 for their spouse, but their spouse is not in the United States, right? And let's say they filed the I-130 in March of 2024, okay? Once the spouse now comes into the United States, let's say their spouse comes into the United States today, right? Today being January 2025. Right now, the visa bulletin is on, I believe it's June or July of 2024. What it means is that it then allows the person who is currently in the United States, who came legally and who is still in status within that 6 months, to then file the adjustment of status and apply for a work permit because they're legally here and they are still within their status and their priority date is current. So it's a little complex understanding like the nuances of green card holders filing, and priority dates and when can they file, when can they not file. But majority of people will most likely fall in the category of a green card holder as of today. If your spouse is here, the odds are that your spouse, and you're just filing the I-130 for the first time, the odds are that your spouse is not eligible for an adjustment of status or a work permit. But this can change next month. This can change the month after that because these dates change every single month, okay? How long does an I-130 take? An I-130 can range from 6 years to 6 years. I meant 6 months to like 17 years. What do I mean by that? It depends on the category in which you're filing. If you're filing for a sibling, you're probably not going to get approved until closer to when your visa will be current, and for most, it could be anywhere from like 14 to 17 years. So if it's just for like a spouse or children under a certain age, and if let's say it's current, you could see anywhere from 6 years. I keep saying 6 years. I mean 6 months. It could be anywhere from 6 months to like 2 years. So that's kind of the timeline. Okay, let me see what else I have on Facebook. I've been ignoring Facebook. I filed for VAWA 6 months ago, along with an adjustment of status, but I still haven't gotten a decision for the EAD. Should I be worried? No. You only filed 6 months ago. You're within a normal process in time. It takes anywhere from 4 to 9 months to get a work permit and a travel permit approval for I would say 80%. What that means is there's still some people that are going to get it later, some people that are going to get it earlier, but you're just within the window where I feel like a decision is forthcoming, and you probably will be getting it somewhere within this window right now. Okay. Chooks on Facebook says, "Good morning, great attorney. I filed for VAWA because my wife is abusive and refused to file for adjustment of status. Now she wants to file for my adjustment of status. How is it possible?" It is possible, but this is my personal opinion, and you don't have to take my personal opinion, maybe because I'm someone who's independent and don't rely on people. If I had an abusive spouse who refused to help me, and all of a sudden they have a change of heart, why would I put all my egg in that basket and my life at the mercy of someone else when there is actually a relief that I'm eligible for on my own? Are people capable of redemption? Absolutely. But it doesn't mean that you should hedge your bets on that person. It doesn't mean that that person wasn't abusive to you. So if you're eligible for VAWA, you file for VAWA. Doesn't really matter what your spouse is trying to do. Finish your VAWA application, okay? Because what happens when you guys have the next fight and you've withdrawn it? I can't tell you how many times that people have come in a consultation and they tell me, "Oh, I filed for VAWA. My new girlfriend, convinced me, so I withdrew the VAWA application, and then I married this new person, and now the person is doing the same thing." And I'm like, man, by now you should have had your 10-year green card, so I always say, there's what we call probability and variables, like using math terms. Humans will be humans, if someone shows you who they are, believe them, so don't put your life at the mercy of someone for something that important if they have shown you that this is what it is. And then for those of you who are in a very loving relationship, you're married to a U.S. citizen, I'm not married, you're dating a U.S. citizen after coming out of an abusive relationship where you were married to a U.S. citizen, I always say to those people, that's wonderful. That's wonderful. But why must you sign the dotted line before you get your green card? Date the person. USCIS doesn't stop you from dating. They don't expect you to continue to stay with your abuser. Date the person, but why must you marry the person? If you're eligible for VAWA because you were in an abusive relationship, file for VAWA. Get your green card that way. One, not only are you not at the mercy of this new relationship, but two, it makes it very clear that both of you are in this relationship for each other and not because of a green card. Because oftentimes this is part of what constitutes conflict in a lot of immigrant relationships, where one person is feeling like the other person is trying to withhold this benefit from them as a form of control, and the other on the other side, for the U.S. citizen, they're unsure if this person wants to be with them just for a green card or because they really love them. So once that is taken out of the table, then you can build your relationship and know that your relationship is based on you guys and what you bring to the table. I hope that answers your question. Okay, let's see what else. Okay. Yeah. So someone says, I've been on that road before. So yeah. So, as I'm sure, he's responding to you, Tris. He's been there, that the person has a hidden agenda. So don't do it. And what do you think about K-1 visas versus a marriage visa? This is a good question as well. And I think it really depends on, I don't know why the light just became super bright. I think this answer really depends on your family situation. Okay, so a K-1 visa in the past would have been significantly faster than a marriage-based case, okay? But now the timeline difference is a couple of months, give or take, anywhere from like 2 to 6 months difference. So the initial incentive of filing a K-1 visa is to get someone here quicker. But if you know that there's already a backlog, depending on what country that you're from, and the only difference is going to be like 2 to 6 months or whatever, or even 2 to 8 months. Why do the K instead of the marriage when it comes with many different penalties? So I'm going to go over the penalties and then you make the decision yourself. For a K1 visa, if you come into this country, if you file for a K1 visa for someone and they come into this country, you have 90 days to get married and to file an adjustment of status. So your process does not end with the K visa and them entering. You then have to then file the adjustment of status. If you don't file that adjustment of status, or if the person comes in and you're like, we can't live together, I hate you, we're getting a divorce, you are no longer ever going to be able to adjust your status while in the United States. You must go back home, right? So all of that was for nothing. And then for some people, depending on if they need to work or if bringing somebody else, another mouth to feed, without them being able to work, would create a burden or an obstacle, then it's not a desirable option. Meaning when you come here in the past, I keep saying in the past, because now everything takes so much longer. In the past, you could come with a K1, while you're doing your adjustment of status, get your work permit right away and start working. But now when you do your adjustment of status, you're looking at 4 to 9 months. So is this something that's going to create conflict between you and your spouse? If it is something that's going to create conflict between you and your spouse or your fiance, then you might as well stay where you are and keep working so you can enter. The only negative for a marriage case between when you're talking about a K1 visa versus a marriage visa is that you're going to come here a couple of months later than with a K1. That is the only negative. But once you come in here, most likely you're coming here with a 10-year visa, because most cases now take about 2 years. Right. And if you come in when you've been married for under 2 years, and you still come in with a 2-year conditional green card. So you have a green card, and that, whether your relationship works or it doesn't work, as long as you have a genuine relationship, you get to stay here, so that's the difference between the two. And look at that, the time is up. I actually have so many good questions, and I feel like I want to answer many questions today. I can't right now, I have a meeting, but I am going to come on live today. I think I'm going to come on live around 3:30 today. So if I didn't answer your question, come on live at 3:30 Eastern today, and I will be on live. Let me put down my alarm so I remember, and I'll try to answer, because I know I've been out of the office for 2.5 weeks, so I know I have a lot to catch up on, and I will answer more of your questions. All right, guys, I'll talk to you guys later in the day. Bye.